Ms. Barnes?
S19A0809, Casey Collins versus Estate. Joel Bergstrom for appellant, Dick Edwards for appellee.
Mr. Bergstrom, when you're ready.
Your Honors, Chief Justice, may it please the court. I'm arguing today on behalf of Casey Collins, who is a defendant in a murder trial who got convicted of 2 life sentences. And I'm arguing an ineffective claim for 2 different reasons. So the first is that his trial counsel did not use an expert that he consulted, and that expert found out that that Mr. Collins suffered from PTSD because the victim in the case, who was actually his grandfather, molested him as a child. The second issue is that counsel was ineffective for not withdrawing after he was basically fired by Mr. Collins. The first issue I want to talk about, I want to talk a little bit about the type of abuse. This was very extreme sexual abuse that Mr. Collins told the expert about. It went for several years, included oral and anal sodomy. He also, the grandfather would let other people come and rape his grandson. They would wear animal masks in this sort of ritualized abuse. And it was repeated over years. He was tied to the bed against his will.
Is there any evidence whatsoever corroborating any of that?
There is from his brother. His brother acknowledged in jail calls that this abuse happened.
Is there more to that? Is there more to that discussion that happened between brothers?
Well, there is more to that discussion. Mr. Collins said to his brother that he was over the abuse at that point, and the state points that out as a reason that trial counsel did not use this information. I don't find that very compelling because that's all he said to his brother about it was, I don't want to talk about it.
But I don't how we measure constitutional ineffective assistance of counsel is not whether it's compelling, right?
Sure.
To counsel. Now, in hindsight, it's whether that could have been the basis for a reasonably strategic trial strategy.
And I don't think it was. I don't think that was a reasonable trial strategy, just based on him telling his brother that he was over this abuse. This is something that was humiliating. He may not want to talk about it. It was pretty clear from the conversation that that's all he said. Oh, I'm over that. That's it. So I don't find that as a reason that a reasonable strategy. The effect this abuse had on Mr. Collins was clear as well. He told Dr. Richards, who was the expert in question, that he was thinking of this abuse during the time of the killing, that he had flashbacks because of it. He used the word blackout. Basically, he saw red. He was thinking of how his grandfather abused him and what that made him feel like, how humiliating this was. And the doctor also said that Mr. Collins was suffering from PTSD because of this.
Your claim is that it should have been admitted as proof of what? Voluntary manslaughter, right?
Right.
Do you have a case that says that the defendant's individual mental condition can be introduced in a voluntary manslaughter case?
I don't. That specifically says that.
And there are many cases saying the opposite, that even if the defendant has severe mental illness, because voluntary manslaughter is a reasonable person defense, we don't look at the individual defendant's condition. We look at what a reasonable person would do, right?
Right.
So how would this, even assuming all of this evidence is exactly as you say, and trial counsel had said, I want to offer this evidence, wouldn't the trial court have said no?
Well, I think that the evidence of the abuse itself could come in as prior difficulties between parties.
You haven't argued that that was a basis for the admission of the evidence.
In my brief, I did not argue that. You're correct. In looking at subsequent case law, I do think that is a solid argument. And I also think that it's relevant towards the defendant's state of mind in this case.
We recently held that PTSD evidence is normally not relevant to, you can't negate intent in Georgia unless you raise an insanity defense.
Right. Well, I think
So are
here...
you saying he should have raised an insanity defense, or he would have just tried to use it to negate his criminal intent?
I'm not saying he should use the insanity defense. I'm saying because of the abuse, it could have been considered adequate provocation for a lesser included of manslaughter.
Can only, if it's manslaughter, our cases say you can't use the defendant's mental condition. So is it manslaughter, or is it something else that you didn't argue?
It's manslaughter, and I think it has less to do with the PTSD than the specific abuse that was suffered by Mr. Collins by the hands of the victim.
But the abuse is relevant, as I think you're constructing it, because you're saying it affected his mental state at the time. Is that right?
Yes.
Okay, so then why doesn't the presiding justice's question answer the question? Why is it not the case that that is therefore not relevant?
Well, again, I think if we focus on the abuse rather than the PTSD itself, and it wouldn't negate everything, because I'm not arguing that this would have made him innocent, certainly. It would have made him potentially guilty of manslaughter if the jury was able to find that.
But the jury would not be allowed to find that under Georgia law.
Would not be allowed to find manslaughter?
If your claim is my client has horrible mental illnesses or has his individualized effect of what the victim said is different than your average person because of all these things that are going on in his head, our law says that's inadmissible, and a jury can't rely on that because we look at, the voluntary manslaughter statute talks about a reasonable person, not a person with all of those issues.
Well, I think that under a reasonable person standard, that if a reasonable person suffered this type of abuse...
That's not how we do it. It's a reasonable person. Would a reasonable person have been provoked? Let me ask you another question on provocation. My understanding of what he said is, I started choking the victim, and as I was choking the victim, I had flashbacks to what he had done to me, and so I continued choking him until he died. Is that pretty much what he said?
Yes, there was some statements like that. Also, what he said to Dr. Richards, he talked about losing control and blacking out.
All after he began choking the victim, right? Not.
Yes.
That's how he framed it. Not, I saw the victim fighting with my girlfriend and blacked out and don't know what happened, but I saw the victim fighting with my girlfriend. I got my belt off and started choking him to death. And along the way, somehow I got provoked.
I think one issue that he didn't specifically say, and I'm not sure that he even realized that, is an issue of control here. The grandfather obviously controlled him when he was molesting him as a child, and now he's controlling him by controlling his drug habit, basically. And it's reasonable to think that he made those connections, whether it was consciously or not, when he was in a situation with his grandfather that was getting violent.
So that's not what any of the testimony was. So from the expert, the testimony was, I started killing the victim, and then I got provoked into killing the victim.
Well, and I don't know if choking him to kill him was his intent at the time. There was obviously things that the grandfather had that they wanted that they took later, the drugs and the money. There was evidence that there was talk of planning that with Miss Cook, of robbing him, but not killing him. So this started out as a robbery, and it got worse as the provocation took place when he started thinking about the abuse.
But didn't the stabbing happen before the alleged provocation?
That's correct. The stabbing happened by Miss Cook, and
allegedly in concert with your client, right?
Allegedly. My client makes different statements to police about that. He was outside the vehicle at the time and allegedly saw them fighting. Whether or not he saw the stabbing or not, it was unclear.
To be clear, the provocation you're relying on is events that transpired from a temporal standpoint remote right? And there's no immediate provocation.
Correct.
And in his mind.
Well, that's right. In other words, it was what he experienced, which to me is exactly the PTSD conversation. You keep saying it's not the PTSD, it's the abuse. There was no abuse attendant upon your client at the time of the event, correct? So we're always talking about post-trauma. It is a abuse that preceded the event by a considerable amount of time, right?
Yes, I think around 15 years. Okay. I think because the abuse was so severe in this case.
Let me stop you there. You talk about the abuse being severe. PJ asked you where that is in the record. Be specific. At the motion for new trial hearing, what evidence was introduced by whom?
Evidence was introduced through Dr. Richards that this abuse was told to him by Mr. Collins. So that was what Dr. Richards was relying on in making his diagnosis.
But you referred to a phone conversation at the jail. To what extent is that in the record? And who said what to whom?
So there was a conversation in the jail calls between Mr. Collins and his brother, where his brother brought up the sexual abuse that he was suffering. And Mr. Collins said something to the effect of, "I'm over that now," or "It's not bothering me anymore."
So that didn't get into the details of the molestation.
It did not get into the details.
So the details of the molestation were introduced through the doctor.
That's correct.
And when the doctor said, based on that, I thought he had PTSD and it might have had some effect on this.
Yes.
And then the state got up and told the doctor a whole bunch of other facts that nobody had told the doctor before trial, like how the evidence actually of the crime occurred, as well as a bunch of other things. And the doctor ended up concluding, well, if I had known that, I probably would not have said that he had PTSD, and I may not have testified at all because I don't testify to things that aren't true.
He did say that would have affected his decision as to whether or not he may be able to testify or not.
And isn't it also the case that the doctor said some things at the motion for new trial hearing that counsel testified at the motion for new trial hearing that he had not been made aware of, meaning there was new evidence, and therefore it could have been the case, as counsel testified, that his strategic decisions and the decisions he made in not bringing the doctor's testimony had a basis that could have been sound because he didn't even hear all the things the doctor was going to say before he ultimately got impeached.
So I think basically the doctor said that he did not know all the information that was told to him. That's correct.
That would have made for a pretty interesting cross-examination during trial, would it not?
It would, and I think that the doctor also indicated...
Discrediting your only witness as to this issue of PTSD.
Well, the doctor also testified that had this gone further, had he requested the trial counsel, had he requested a report or potential testimony, he would have done a further investigation into this as far as doctor records, family records, testimony from family members that would show that this abuse took place.
And what would that have shown? What in the record would that investigation have shown?
Well, we know from the record that the brother was well aware of this abuse.
No, we know that. I mean, the brother mentions that there was some sort of abuse, right?
Yes.
None of that call is about all of the details that your client supposedly told the doctor, right?
That's correct.
Okay, that's all we know. That there was some sort of abuse, undefined in any detail, that your client says he had gotten over. That's all that you get from the brother.
I think it's clear that it was sexual abuse in nature from the phone call. And there was also some talk later about a bar complaint and the other complaints that Mr. Collins had against Mr. Ivan. And part of that was conversations that Mr. Ivan had with his mother about both the abuse, about plea bargains, and things of that nature. So it could be concluded that the mother was aware of this abuse as well.
It could be maybe concluded, but to prove that trial counsel was ineffective in not calling the doctor, the record as it stands is your client told the doctor a bunch of things that formed an opinion of the doctor, which probably wasn't admissible. But if you get past that, you say the doctor, and then the doctor said, if I'd been told the other facts the state told me, I would not have given that opinion, and I might not have agreed to testify. And then you say, well, there should have been more investigation. Well, to prove that the doctor would have swung back to his original, somewhat inadmissible opinion, you would have to show us what that investigation would actually have uncovered. And all you're saying the investigation would have uncovered was a jail call and the mother's kind of vague discussion in plea negotiations?
I think that there's also some evidence just in the discussions between Mr. Collins and the doctor of who his family doctor was currently.
All of that, unless you have gone to show us what that doctor would say, it's all speculation. For all we know, if you went to that family doctor, he would say, defendant denied it up and down, and I saw no signs of any problems.
Well, we do know about some of the prescriptions he had been on in the past that point to depression and anxiety and things of that nature. So I think it could be shown that that there was issues he was suffering from that were related to somebody suffering from PTSD from extreme abuse. I wanted to mention the Strickland two-prong test as well in relation to the to not calling the expert here. Here, the first prong is whether or not this performance was deficient on part of the trial counsel. It's our position that it was defective. Mr. Ivan, the attorney, got funds from the state to hire this expert for a mental evaluation, and all that took place after was a 30-minute conversation with him. He didn't ask to follow up with a report. He didn't ask to have the doctor do any more investigation. He was just told in the 30-minute conversation, looks like he has PTSD, and that's where it was left. Had it been further investigated, as the doctor said, what his normal course would have been is to consult with the family, consult with prior doctors, look at prior prescriptions, look at his entire medical history of his past, which was not done because the trial counsel didn't ask for it to be done. The second prong is whether or not it prejudiced the defendant and likely would have changed the outcome had this testimony come in. I think it would have been extremely relevant for the jury to hear that the victim in this case had prior difficulties with Mr. Collins that involved this extreme form of abuse. I think they could have and should have found that it would be adequate provocation under the manslaughter statute, which would have changed the potential punishment for Mr. Collins from 1 to 20 years instead of the 2 life sentences that he got. I want to talk also a little about why the trial counsel, why he claimed he did not use the evidence at trial. He talked about his the brother's jail call again, that he thought that this would have refuted any claim of abuse by him telling his brother that he was over this. Again, I don't think that really is relevant on what he told his brother in one conversation about the abuse. That would not be a reason to throw out this entire potential defense here. Also, both the state and trial counsel were concerned about the abuse being admissible. The state's brief mentions character evidence, that it would come in, it shouldn't come in as inadmissible character evidence. I don't think that this is character evidence. I think that this is prior difficulties between 2 parties. That would be an admissible reason to use this for. The state argues also that this was not PTSD, that this was basically lies that were told to the doctor to try to get him to say certain things. Dr. Richards is highly experienced in this type of legal arguments and this type of diagnoses. He's used all the time in courts. He's got a long history of testimony. I think that his opinion it's sought after. I think that it's trustworthy, and I think that he'd be in the best position to know. And I think that also, because he's so experienced, I think that if Mr. Collins was simply lying about everything he said, that Dr. Richards would have been able to tell that.
That may be why when the doctor was told things that he wasn't told before trial, he said, I probably would change my opinion and wouldn't testify.
Well, I'm not sure if he said he probably would change his opinion, or it may have had an effect on his opinion, and that may have had an effect on his testimony. So my argument is it's unreasonable not to use this expert when it could have potentially gotten a manslaughter charge. There's more talk about that there was a decade, at least, of cooling down period. Here, I think because there was talk of flashbacks, and the doctor actually testified that PTSD does have some forms of losing control, that that the cooling period would not have been relevant here.
Thank you, Mr. Bergstrom.
Thank you.
Mr. Edwards.
If it pleases the court, my name is John Edwards. I'm here on behalf of the Appalachee State of Georgia from the District Attorney's Office of the Cobb Judicial Circuit, addressing appellant's first enumeration. I believe there are two overriding or primary reasons why trial counsel in this case was not ineffective. The first is that the expert that testified at the motion for new trial hearing, Dr. Kevin Richards, effectively recanted his opinion under cross-examination. The second reason is that trial counsel had reasonable strategic reasons not to introduce evidence of the post-traumatic stress or of the sexual abuse. Now, as the trial counsel's was Michael Ivan. He was appointed. During his testimony at the motion for new trial hearing, he testified that as he was talking to Dr. Richards, and Dr. Richards was giving his opinion, something that was going through his mind was, or his considerations were, what Collins had been telling him in their many interviews, and also what was in the jail calls. Trial counsel testified that Collins never said any of these things to him about what he was thinking or anything like that while he was choking his grandfather. In addition, the jail calls were, which did not come into evidence in the trial, but that the trial counsel was aware of through discovery, and he testified about during the motion for new trial hearing. Those jail calls were, in trial counsel's words, debunking of what Dr. Richards was saying. For instance, in talking to his brother, Collins said, "I got over that 15 years ago." And at another point, they were in a discussion about Collins' relationship with his grandfather. Collins talked about going to see him just to watch football games and enjoying his company, and remarks like that, and which would have been entirely inconsistent with what Dr. Richards was telling trial counsel. Trial counsel concluded in his testimony that not only would it be strategically bad for him to use that type of evidence, but he used the phrase that it would have been strategically stupid for him to use a defense that had been debunked by Collins. So that was, and he stressed over and over that was his primary strategic reason for not wanting to use it. It's important to point out in Dr. Richards' evaluation and in his testimony that he concluded that Collins was competent to stand trial, so there was no issue of competency there. Further, he concluded that there was no issue of insanity, so there was nothing on which to base an insanity defense. And where there is no issue of competency or insanity, and there was, and during the motion for new trial hearing, he was also asked about delusional compulsion. That was not present either. So there were none of the statutory defenses that trial counsel could have asserted. So where there is not a mental health defense, introducing mental health type evidence such as PTSD is simply has no bearing on an issue on mitigating malice to the extent of voluntary manslaughter. To have voluntary manslaughter, there must be sudden, violent, and irresistible provocation, sufficient to excite such passion in a reasonable person. And where this mental health type evidence, such as PTSD, relates only to the defendant, then that's not showing this sudden, violent, and irresistible provocation that would excite passion in a reasonable person. It's specific to the defendant, and this court has called that type of evidence irrelevant. Now, a case that I think is instructive on this, factually it's almost on point. As far as the ultimate issue, it diverges somewhat, but a case this court decided in 2018 called Prothro versus State. In that case, the defendant also killed his grandfather. He also killed his grandfather because the victim refused to give him money that the defendant wanted to use to buy drugs. And like in this case, he robbed his grandfather's body of his wallet, and in that case, his car keys, drove away in his pickup truck, and used his debit card to buy things. So it's very similar in that respect. Now, in that case, the alleged ineffective assistance of counsel was that trial counsel made a last-minute request for funds to get a psychologist to do an evaluation. It was very late. The trial court denied it, and that was cited as ineffective assistance of counsel. At the motion for new trial hearing, they produced a psychologist who testified that the defendant was generally very upset in the time leading up to the murder, primarily because of his alcohol and drug usage, and at the time of the murder, he was, quote, out of his mind on drugs. All that evidence was found to be inadmissible or not relevant for the reason I discussed earlier, because it had to do specifically with the defendant's state of mind, not what a reasonable person would how it would react. It would not be provocation to a reasonable person. And I forgot to mention that the defendant's argument in Protho was that the mental health testimony would have garnered him a charge on voluntary manslaughter, which is exactly what the appellant is saying in this case. Now, turning to the second enumeration of error, as I read the appellant's brief, they're saying that because Collins made a bar complaint, that trial counsel was automatically disqualified to represent him further from that point. I don't think that's a correct analysis. Even where a bar complaint alleges ethical violations, the analysis is still under the two-pronged test of Strickland versus Washington. And I don't think there's any argument here that the only argument that I can discern regarding prejudice on Michael Ivan going further is speculation that a new attorney would have made the investigation that they say he should have made, and that then Collins would have gotten a jury charge on voluntary manslaughter. In that regard, almost skipping back to the first enumeration, at the motion for new trial hearing, the appellant introduced no evidence from what they say trial counsel should have found in an investigation. They talked about school counselors, DFACS reports, other psychologists, and I believe a Dr. White. But none of those people testified, and there was no other evidence of anything else concerning mental health or PTSD. So, in addition, on the second enumeration, there was a hearing, I think a couple of days before trial, or shortly before trial. And it came to the trial judge's attention because of remarks, again, in jail calls that the state heard, critical of trial counsel, and the state brought this to the trial judge's attention. In that hearing, the judge questioned Collins fairly closely about if he was happy with his representation, and he gave Judge Poole no indication other than that he was happy or satisfied and wanted to go forward with his current counsel. And I think all that goes to showing neither deficient conduct or prejudice regarding not withdrawing as counsel. So if the court please, if there are no questions, I'll conclude. Thank you.
I believe you're out of time. Is that correct?
Yes,
Okay.
I was at time.
All right. Well, thank you, counsel, on both sides. I neglected to mention at the beginning of the arguments this morning that Justice Ellington will be participating in all the cases. He's at home recuperating, but he's fully involved. Thank counsel for both sides. Let's take a